The Bloemfontein High Court has dismissed Nandipha Magudumana's bid to have her arrest in Tanzania declared unlawful with costs. For a look at the legalities of this judgment, we're joined by legal expert Mpumelelo Zikalala. Thank you very much for your time this afternoon. Is it a surprise to you which way this went?
No, not at all. In fact, on the agency alone, I thought the court would have said we're not going to entertain any further arguments on this one. However, the court was lenient in terms of saying, even though the agency, strictly speaking, is not there, however, it's in the interest of justice that I hear you are dealing with a very important matter of your freedom of movement or a potential violation of your constitutional rights. So I'm going to hear and deal with the merits of the matter in which the court inherently that's what it did when it discussed the modalities and the sequence of events that actually took place, and then finally came to the conclusion that said your consent then allows us to overlook all the other things that might have taken place, and you should go and stand trial in a South African court.
In fact, this is what the judge said on consent. Let's take a look, listen.
In the present case, I have no hesitation in finding that the applicant was well aware at the time of her handing over of the charges that could be leveled against her upon her arrival in South Africa. She nevertheless consented to her removal from Tanzania to South Africa because she wanted to be with her children. At the very least, she had willingly acquiesced to her transportation back to South Africa.
Now, that may be the case, but what did you make of the judge's interpretation of the deportation disguised as an extradition?
I would say it was a close call, because if it wasn't for the reason of the consent which has been established by the court, it may have been that this could have been regarded as an extradition disguised as a deportation. The presence of the officials from South Africa is certainly an alarming, and it's a sign or an element in which the judge took into consent. Another one is the submission of the Minister of Home Affairs affidavit. If that particular affidavit was not submitted, the information pertaining to how the actual handover took place would not have sufficed. It would have made it into the court to be assessed by the court. So it may be looked at, it may have been something that may have caused or swayed the judge to decide that an extradition was definitely taking place, disguised as a deportation, but we stand maybe at another stage for that particular process to be evaluated. And what stood out for me was this point of saying, I think the element which was looked at by the court was that if it was another individual, not Dr Nandipha Magudumana or Thabo Bester, wouldn't have the law enforcement agencies of South Africa been present all the time, negotiating or having discussions, no matter which word you want to use, on behalf of South Africa as to how this particular process is supposed to go through. If the answer to that is no, then it means that it is a unique case. There's exceptional circumstances that are there that might give an indication that the nature of the discussions which were taking place between the two countries was then to say, we have a fugitive that we are looking for from the South African side, and Tanzania was simply saying, we are going to assist you, South Africa, in getting the person that you are looking for to come back to your country. Strictly speaking, that speaks there, or it is made up of the elements of an extradition process and not a deportation process. However, the judge was quick to alert the fact that at the end of the day, the decision whether to extradite or whether to deport rested solely with the Tanzanian government, and it is only at that time in which Dr. Magudumana ought to have raised this particular consent and challenged whatever process or decision which was taking place in Tanzania.
Speaking to Newzroom Afrika earlier, her lawyers indicated that they will take instruction from their client. Should she appeal, what are the prospects of success?
They might be slim. Remember that when you appeal, you're only confined to the records that you have. Now, in this case, the court was very clear in terms of saying that even on the agency, they were, for a lack of a better word, doing her a favor. So if that's the case, then what makes you think that another court might come to a different conclusion? Secondly, the sequence of events and the number of inconsistencies or the clashing between the two affidavits and the preference by the judge of taking the affidavit which has been submitted by the respondents definitely says that maybe your chances of going to a higher court are not going to be that high. Rather, leave the situation as it is, go into the magistrate court, apply for bail, get your temporary freedom, and then be able to deal with the matter when you are outside. At least if you go for a bail application now, you stand a much better chance because you have 4 accused which are in front of you. You have listened to how the court would want those particular evidence pertaining to Section 6 of the Criminal Procedure Act, detailing your exceptional circumstances and why you should be released on bail being discussed. So you stand a much better chance of submitting information that is going to aid the court to releasing you on bail than it would have been in the earlier stages.
Speaking of the magistrate's court and that process that still has to play itself out, what bearing does this process or this process that has now concluded have on that process when she appears on the 20th of June, if at all?
It won't do anything. It has no bearing at all for now. However, once the case actually starts, I foresee these particular points being a bone of contention between the state and the accused, in terms of saying, please explain to me that the nature and the manner in which you've arrested me, any other points in which I can attack on. That's exactly what I'm going to do. Remember, when you go into a court backlist, either on a procedural basis, on things that were not followed, or on the substantiveness of the case that I have, on 2 points, if any of those 2 points are not up to scratch, it may lead to a acquittal depending on the gravity of the non-procedural aspect that has been followed. So even the collection of the evidence once the individuals are now in South Africa, all the other witnesses that are there and how the particular evidence was gathered is going to play a very crucial role. Now, it gives you an insight of saying that when the trial comes, definitely the manner in which the information was collected is going to be under scrutiny. So state must take note that you make sure that when you present evidence during the trial stage, you have done your homework in terms of closing all the loopholes that are there, because definitely when the accused are interrogating the particular evidence that you are going to present, the procedural expert is not going to be left alone.
For the bail hearing and bail application, as you mentioned, her legal team would have had an opportunity to then hear what the court would want to hear, for lack of a better expression. What are the prospects of success given the flight risk notion?
Well, it depends how you want to argue it. You may say the mere fact that I was caught in another country does not mean that I'm going to engage in another act. There are preventative measures that can be implemented to stop the particular individual from fleeing off. The first one, what has been used, I think is accused number 8, if I'm not mistaken, reporting to a police station from the every morning and in the evening, the taking away or confiscation of all travel documents that are there. I can even move to another place, or a place which is closer to where law enforcement agency would have to have sight of me as to exactly what I'm doing. And another one, use the advantage of the media coverage that you receive to your advantage. Now, everybody or most of the people would know by now who Dr. Magudumana is, and how easy is it going to be for her to escape the country when you are a well-known individual in that particular manner, and you can't disguise yourself so that you are able to go through the border gates in an easy manner. So all those particular points will have to be lamented, but also understand the following point with the onus of proof when it comes to bail application, that it comes from you as the applicant. So stage all those preventative measures. Assist the court in suggesting to it that this is what I'm prepared to abide by. If you give me bail or you grant me bail, this is what I'm going to do to make sure that the interests of justice are protected, the evidence is well concealed and protected, is not going to be tampered with. I'm not going to evade trial due to the things in which I'm going to comply with at the end of the day. So your non-granting of bail to me is actually an injustice when I've voluntarily submitted myself that I'll abide by all these conditions which are meant to assist everyone. I'll get my temporary freedom while making sure that the wheels of justice are grinding in a normal manner.
Of what bearing is the schedule of the crime, in spite of the arguments for or against bail, does it have in a person ultimately receiving bail? The 5 co-accused last week, 4 of which were denied bail. It was said it was Schedule 5 offences, which are serious crimes, and the one that was granted bail, it was a Schedule 1 offence.
Well, the minute you say 5 and above, you need to prove exceptional circumstances that might be there. Now, in addition to all the questions which are detailed in Section 6 of the Criminal Procedure Act, you then have to go an extra mile. I put it the cherry on top in terms of the factors that say, really let me look into the circumstances in which of how I was arrested. You can even at that, the weakness or the strongness of the case against you. Any other factor is going to assist the court in arriving at a conclusion of saying that indeed I am an individual or a candidate that is eligible to be released on bail. Now, The minute you say Schedule 5 and above, exceptional circumstances have to be there, and you really have to concentrate on them and say, this is what I want to achieve. So I want to try and identify those exceptional circumstances to this case and be able to allay them to the court, and so that the court will be able to find in my favor.
Mpumelelo Zikalala, thank you very much for helping us make sense of the legal aspects of this case.